Hello, I'm Meetali Singh and I'm currently working as a legal intern at LEXIS and Company. Today, in this video, I will be discussing the jurisdiction of criminal courts in respect of inquiry and trial. So, we'll first understand what is the meaning of trial and inquiry, and then we'll jump onto the jurisdiction of criminal courts in respect of both these aspects. So, let's start. Criminal law can be classified into procedural criminal and substantive law. The substantive criminal law is constituted under the Indian Penal Code 1860 and Dowry Prohibition Act 1961, while the procedural criminal law is mainly governed by CRPC 1973. There are various functionaries under the code, and these functionaries perform their duty or discharge their duty according to the code. And these functionaries are first the police, second, the prosecutors, magistrates, and the judges of the high courts, and defense counsel, etc. However, the major role is exercised by the magistrates and the courts. The criminal cases are tried by first the Supreme Court in cases of appeal mentioned under section 374 and 379 of the code. Second, the criminal cases are tried by the high courts as mentioned under Article 227 of the Constitution of India, power of superintendence over all the courts by the High Court, that every High Court shall have superintendence over all courts and tribunals throughout the territories. And the last one is the criminal courts. Criminal cases are tried under criminal courts also as mentioned under Section 6 of the Indian Penal Code. Now we'll jump on to inquiry. So according to section 2G of the code, every inquiry which does not come under the definition of trial, which is looked into by either the court of magistrate or by any other court so authorized under the code of criminal procedure, this means and includes all those proceedings before framing of charges. चार्जेस फ्रेम होने से पहले जितना भी होता है, जितना भी उसमें इंक्लूड होता है, उसको वी टर्म्ड एज इंक्वायरी. Hence, it means every inquiry other than a trial which is conducted by a magistrate or a court, वो जितनी भी इंक्वायरी होगी वो इस इंक्वायरी के डेफिनेशन में आएगी अकॉर्डिंग टू सेक्शन 2G. Now we'll jump on to the trial. So what is trial? Trial starts when the inquiry stops. In case of the nature of an offence is determined to be of a criminal nature in the inquiry, then only the trial starts. If it is not of a criminal nature, then trial does not start. If the offence is determined to be of a criminal in nature, then the trial starts. Trial helps to determine whether a person is guilty of an alleged offence or not. Now let's understand the jurisdiction of a criminal courts in respect of inquiry and trial, which is the main topic of this video. Section 177 to section 189 of under chapter 13 of the CRPC describes the jurisdiction of criminal courts, that is to determine which court shall try the particular offence. So first, section 177, ordinary place to inquire and trial. Every offence shall ordinarily be inquired in land tried by a court within whose local jurisdiction the offence has committed. This section basically states that the offence shall be tried by a court under whose local jurisdiction or territorial limits the offence was originally committed. Now section 178 states that place of an inquiry or trial. First, when it is uncertain in which of the several local areas an offence was committed, or where an offence is committed partly in one local area and partly in another, or where an offence is continuing one and continues to be committed in more local areas than one, or where it consists of several acts done in different local areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas. Next is section 179, offence triable where act is done or consequences ensues. When an act is an offence by reason of anything which has been done and of a consequence which has ensued, the offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequences has ensued. Section 179 states then when an offence takes place in the local jurisdiction of one court, but the consequences from such offence occurs in the local jurisdiction of another court, the said offence may be tried or inquired in any of the court under whose jurisdiction either the offence took place or its consequence occurred. Now we'll move to section 180. Place of trial where act is offence by reason of relation to other offences. When an act is an offence by reason of its relation to any other act, which is also an offence or which would be an offence if the doer were capable of committing an offence, the first mentioned offence may be inquired into or tried by a court within whose local jurisdiction either act was done. Simple language, section 180 states that the offence which has been committed first must be inquired into or tried when two acts are done which are connected and are offences in the local jurisdiction of the court under which it took place. For example, a charge of receiving or retaining stolen goods may be inquired into or tried either by the court within whose local jurisdiction the goods were stolen or by any other court within whose local jurisdiction any of them was at any time dishonestly received or retained. Thank you. That's it for this video, and I will continue the remaining part in my next video. Till then, do subscribe to the channel for daily updates. Thank you.